then I think you have to pay for somewhere. I mean, to that extent, I think if final hearings don't take place 5-6 years, if they are, of course, whatever are pending or still pending, if you are able to resolve within 1.5 years or so, I think this may be a price one has to pay for. To quote Justice Chinnabrati, I'll say that the price you pay for civilization. But couple of points which I thought on this, which I should bring to your attention, is that the clarification from the board as well says that the pending appeals and stay will be dealt with as per the laws existing prior to this amendment, which really means that, your vagaries of this, of being in that 180 and 365 days, we will continue to be in that syndrome for that, for the pending appeals. And although I may be aware, saying that all this started because of an amendment which was brought in. Of course, the amendment came in 2002 as per 180 days is concerned, but there was an further amendment made in 2013 that 365 days the stay will expire automatically. And this was inspired by section 254 2A second proviso to Income Tax Act. And because there were two judgments of the one of the Karnataka High Court and another the Delhi High Court in the context of section 254 of the Income Tax Act, holding the tribunal does not have the power to extend beyond 365 days, the Delhi bench presided by the president also had taken this view, saying that we don't have power. And there was also a judgment in the context of indirect tax also of the Allahabad High Court, where they had also said that there is no further power. But one way of one line of argument was that it stands vacated doesn't mean that you have no power. Your inherent powers are there, you can extend further, but one has to come up with an application to you, to the tribunal, and they have to extend further. And of course, provided there are no dilatory tactics on the part of the taxpayer, because huge demands, you keep on seeking adjournment so that you can keep it in the wraps. This was the understanding, but of course, now all that is gone. And it was pointed out subsequently, I think about 10 days back, to the same president's bench in Delhi, saying that the income tax provisions and the excise provisions are not exactly pari materia, and there is also a sunset clause. The matter has been referred to a larger bench, and the matter before to a larger bench now. I am saying this because if you take the leaf out of the clarification given by the board, saying that for pending matters the old law will apply. If you really apply the same thing to all applications and appeals filed before 2013, then we are not aggrieved at all by this amendment which came in 2013. I mean, you should not be, really. If in spirit, this is what the government's understanding, contemporaneous authorities' understanding is, that the law at the time of filing of the appeal or stay order will prevail. Because most of it, which is 365 days, amendment came in 2013, but we are just about 1 year. So all those appeals which are filed earlier to that should not get hit at all by this, and they should get covered by the earlier judgment of the Supreme Court in the case of Kumar Cotton. I mean, there's one line of argument I'm just saying. I mean, it's possible. Advance ruling benefit extended to residents, private limited companies, as we saw in the case of customs. Clarified that the excise duty exemption also available to subcontractors. This is a very welcome move, because if the main contractor is in the ICB, it will also be extended to subcontractors. I think there has been huge controversy on this, whether it should be only to those contractors, only to those people who are under ICB, or also to the subcontractors. I think it's only a logical extension. I think it's a welcome amendment again. Levy a 1% penalty per month of duty default introduced. Earlier, the mandate to pay duty was on every consignment till the payment of outstanding duty and interest. This has been relaxed now. Applicants can approach, I think I mentioned this earlier, settlement commission even the return was not filed.